Steve Graybeal, and today I'm broadcasting from my office in Moriarty, New Mexico, and my co-host and producer of the show, Dennis Burgess, is broadcasting from St. Louis, Missouri. So I guess last week we had no show because we uh, got kind of busy. Dennis, did you catch up with all the stuff you were supposed to be doing?
I'll tell you what, man, we've been so busy, and that's a good thing. I mean, we got a lot of things going on, both internally as well as many customer projects, and it really shows that it's the holiday right now because we have lots and lots of customers that are trying to wrap up these projects this week and next week. Everybody wants to get done so that they don't have to do anything else during the holiday week, the New Year and Christmas and such. So really good stuff. I love getting all these projects done. And what's also nice is that a lot of people are starting to go, oh, wait, I need to get this done before the end of the year. So all of a sudden people want to get it done. So a lot of projects that have been sitting out there for a little while, all of a sudden, guess what? Everybody's looking at trying to get it accomplished and completed very, very quickly. So really good stuff overall. And as the industry is growing, we've definitely had lots and lots of we actually have had quite a few new customers. We have some new vendors. We have lots of things going on this year, and so far it's been a really, really great year. On the side note, for me anyway, we actually finally got all of our Telerad training in-house. So we actually got all of the extended engineering training that our engineers need. So that's really good stuff as well. So again, good stuff for us. We finally got that accomplished, and we just keep going, man.
Yeah, it's interesting you mentioned the guys spending money. They come to this time of year going, uh-oh, I made profit. I got to make some expenses.
Yeah,
Which
yeah.
is what I did. That's why I'm back in New Mexico. We yesterday spent all day erecting a 30-foot tower for a place in the middle of nowhere, New Mexico, to provide internet for a realtor who wants to sell more land, because if he doesn't have broadband in the area, he's not selling land, so he thinks. So
Well,
we put up a tower yesterday, and
makes sense to me.
we got the gear, the dish up last night around 6 o'clock, kind of in the dark, and we're pointing it. And sure enough, the analysis I did on Google Earth pinpointed me on the tower I was going to use. But yeah, we're hustling to get a couple of projects wrapped up before the end of the year, like you said. Get them done within the next 2 weeks so that I can go back to California and be with the family.
Yeah, that's always a good thing, to be able to be with family and don't have to worry about it. Hopefully your network's redundant, so you don't have to worry about sitting there and something breaking and you have to run off. That's
Yeah, the beauty of it is I can do most of all my work from out there. I just can't have feet on the ground here.
I understand.
Well, on today's show, we've got an interesting show from the legal counsel for WISPA. We got Steve Coran and Dennis Corbett with Lerman Center, and they're going to be talking about a court battle that went on just recently and inform us all about what's going on in that realm to keep our internet as possibly free as possible, I think it is. But anyways,
Open.
Steve and Dennis, you guys there?
We're here. Can you hear us?
Yes, we can hear you. I appreciate you guys coming on the show, right after this court case that you guys were involved in, and telling us all about what's going on in the world of the FCC trying to regulate us into the ground. So with that, I let you guys take it away.
Well, thanks, Steve, and thanks, Dennis. And Steve, I note that you have a certain bias about this, and I think, like a lot of wireless ISPs, you do see what is going on in the D.C. Court of Appeals as kind of a challenge to the FCC's authority to regulate the internet. Last February, the FCC adopted open internet rules, and in March they released an order. And a number of things in the order, but the thing that got the most attention and which has been sort of reduced to net neutrality and setting apart the ideologues on either side of yes, we want the open internet, but yes, we need Title II regulation as a public utility versus yes, we want an open internet, but we don't think that the FCC should do anything more than continue the light touch regulation it's been using for the last 20 years. So that's sort of where you had the name calling and back and forth, the kind of political argument. In the middle of all that was, hey, we're the small businesses and we don't want to get run over by these big forces, and we're especially exposed to a lot of the regulatory harm and risk that could come about simply from members of the public choosing to exercise rights under Title II, namely filing complaints with a court that certain practices are not just and reasonable. Quick overview of the FCC's order in adopting Title II. What does Title II mean? And Title II was adopted to regulate telephone monopolies in 1934. It was based on regulation of railroads back to the time of Teddy Roosevelt, probably 100 years ago. And the FCC did, and what is in Title II is a couple of sections that says you are operating as a common carrier and a telecommunications provider, and that means you have to make your service available to anybody who's able to receive it, and you have to provide it on fair, reasonable, and non-discriminatory terms. It means that companies can and consumers can file complaints either at the FCC or at a court, whereas before there would be an enforcement action, in which case that did not create a private right of action. And there's a fear here, a substantial fear here, that that the FCC has opened the door to class actions and to complaints that would go after small guys, because we all know that Comcast and AT&T and Verizon would throw armies of lawyers at these things and try to repel the complaints that would be filed. There are other things in here, and we will get to those as we kind of walk through what happened in the courtroom, but I think providing that framework gives you an idea of some of the fears that we all think is happening or could happen. As I like to say, the sky would not fall at once, but it may fall in big chunks. It may not fall at all, but we have to kind of protect ourselves against the forces of evil that could come about. Once we took a look at the order, WISPA's board made a decision to join in an appeal with with several other petitioners. Our group included, and I want to make sure I get them all, U.S. Telecom, which represents large carriers, CTIA, which obviously represents the mobile interests, NCTA, the National Cable and Telecommunications Association, ACA, which is the American Cable Association that represents small cable providers. Let's see, there was CenturyLink and AT&T and WISPA. So we were the group of 7. There was a separate group that was Alamo Broadband, a WISP out of Texas, along with a internet activist by the name of Daniel Berninger. They were in a second appeal. And then the third group was a group called Full Spectrum Network. They're a group of CLECs, and we'll talk about their issues as we kind of step through this. So briefs were filed over the summer, reply briefs, intervener briefs, and on Friday morning at 9:30, people were lined up literally 7 in the morning, probably before that. Dennis and I were very fortunate to get reserved seats so we could just show up and get a nice seat in the courtroom, but it was, they used the double wide ceremonial courtroom on the 6th floor here at the BC Court of Appeals. Our panel consisted of 3 judges, and it's actually a very diverse panel, I think we would say. One is Sri Srinivasan, who is appointed by President Obama, reported to have aspirations to Supreme Court. Bright, young, very well spoken, as they all are, judge. At the other end of the spectrum, you had Judge Stephen Williams, who's actually retired and in senior status. He's in his 80s, but still very mentally sharp. I think he was, eyeballing his laptop while we were during the argument and asked a lot of great questions. And then in the middle, you have Judge David Tatel, and Tatel is very well respected as a jurist, and he was the one who authored the opinion in the Verizon case back in 2012 that led to this, that took us to where we are, based on the 2010, the appeal of the 2010 rules that vacated the FCC's decision and previous decisions. So very internet savvy, and I think judging from the questions they asked and their level of engagement, I think they were all very well prepared and tried very hard to ask great questions, and I think they succeeded. Dennis, add anything to that?
I actually have a question real quick before you keep going. So this was a court that both a number of groups and the FCC came into. This was not like an FCC proceeding or anything like that.
This was oral argument, and it brings out people and lawyers who do nothing other than appellate advocacy. And the FCC, there were interveners on both sides. These are folks who file briefs, and they do so in a way to sort of give a different perspective, and sometimes they're allotted time to also join the oral argument. There were 4 segments to the oral argument. Ours was in the first 2, and then there were other lawyers who argued in segments 3 and 4 on their issues, which we'll come to in a second. And the FCC had a little help from a couple of interveners, one for Dish, and I think the other was for the public interest groups on a couple of their issues. So they yielded some time. On the reclassification issue, the FCC's lawyer was their general counsel, John Sallet. I don't know if he does a lot of appellate advocacy. Dennis is shaking his head no. But he, I think, did so because A, he's the general counsel, and B, he owns this. He owns reclassification. And I think he really wanted to do this, and talk a little bit about our perspectives on how the FCC did.
But I think what I'd add is that these cases occur when the FCC takes an action and someone in the affected universe feels strongly enough about what happened that it was an adverse impact. It justifies them going to court. So we're out of the realm of the FCC itself and into a different realm of court review of what the agency did, in which typically the FCC holds some pretty impressive cards. It's hard to get a court to undo what the FCC has done, but that's what this case is about, and that's what all appellate cases are about. The FCC has a pretty impressive track record of defending its actions in court. That's in part because deference is typically given to the expert agency. They're given a lot of leeway, and courts are not there to second guess what the agency did. They need to be given a reason why what the agency did was unlawful, contrary to a statute, for example, things like that. This case generated so much public involvement below, and it is such an important issue because it involves the internet and its importance in the general American economy, that it was treated as a historic importance. It is of historic importance. That's why Jonathan Sallet argued for the commission as well, and why there was a capacity crowd in the courtroom, overflow crowd, a lot of press coverage, because this has to do with a very fundamental question of whether the FCC is a regulatory agency empowered to reach the internet or not, based on the statutes that exist. So it had a flavor of importance and history to it, which was what was kind of fun to be there. Now, I will say also about the judges that they were diverse. It was 3 hours long with a 10, 15-minute break in the middle. Very long period of time as these arguments go. It's about as long as it gets. But another indication of how important the court considered it to allow that much time. But they were, all of them, fully engaged during the entire argument. They asked questions in about equal number, I'd say. It's hard to say who was the predominant questioner because they were all interested, which is also not always the case. Sometimes one judge will take the lead. It's a 3-judge panel after all, and they're not always the same, but in this case they were. A little side note for color is that Judge Tatel is blind, and my understanding from birth, and yet he's very impressive. He is extremely well prepared. Justice is best when it's blind, actually. It's a nice image to have. But he's fully engaged. He wrote the last opinion, and he asked we'll get to that, some of the questions he asked, but that gives you a little more. And he's sitting as the center of the 3 judges as the advocates are making their pitches to him, and to all 3 of them.
So I still want to go back to the original question. So this is the opening arguments or the oral arguments, the start of the actual court case of People versus the FCC stating that Title II is bad.
Well, not exactly, Dennis. I mean, the opening salvos are all of the written briefs that have been filed over the summer, hundreds of, well, thousands of pages and hundreds of thousands of words. So once the briefs are filed, then the parties lobby with each other and petition the court for how much time they're going to get at oral argument. An oral argument is a one-shot deal to go in and as Dennis was saying, make your pitch to the judges orally. They have an opportunity to ask questions, to test their assumptions, to put you on the spot, to maybe send a message to the other side while they're doing that, what they should be prepared for. They're all different things the judges do when they ask questions. And some people try to read into their questions to try to divine where they are on these things, and I think that's kind of a fool's errand to do that, because you simply never know. We can draw certain assumptions about how we felt the judges reacted to a particular argument, but to say that because a judge asked this question, it meant that he disagreed with everything the FCC was saying or agreed with everything the FCC was saying is kind of the wrong way to approach it. So from here, the judges will take all of the briefs, all of the oral argument transcript. They'll do their legal research with their law clerks, and we should see a decision sometime between March and May. At least that's the best estimate of when we might see a decision from this court. And it will be a written decision, and it can be anything from we uphold the FCC's judgment on all issues, we vacate the order and remand it to the FCC on all issues, or anything in between. And I think we'll wait to the end to sort of make our very measured and calculated prognostications, but that's sort of where we are. And then what happens after that, depending on what the FCC does, is there a Supreme Court appeal in the future? I think a lot of people believe that there will be.
Another way to answer that is that the oral argument is actually the last act before the decision itself. There's a lot that's gone in before the oral argument in all the briefing. And in addition, in a typical case, although it's not open to us to know and we're not privy to the judges' deliberations, they will typically meet before the argument to get some sense of where the case might be headed, because after all, they have to decide it after the argument, and they will maybe trade issues that they're going to focus on, and maybe even give preliminary indications of where they're leaning. Typically, after the argument, they'll meet fairly quickly to make some sort of preliminary decision about where the case is going to go, which of the three of them will write the opinion, and what it will say, whether they're all on the same page and they're all in agreement about the results. Oftentimes, there can be a 2-to-1 split. So they'll have to get those things sorted out pretty quickly after oral argument to get the wheels in motion to write the decision. However it's going to come out, who's going to write it. So this is really, a lot has already gone on in the judges' minds before they step in to hear the argument. They've read the briefs, they have leanings, but they won't share them with you, the public, but they have them. And so that's why people try to read their questions as tea leaves. But I agree with Steve, it's a perilous and risky enterprise because they can just be, testing theories and trying to probe without necessarily revealing their leanings, but they have them.
Excellent. So, again, we're just talking about that I'm just trying to make it step way back. This is all the proceedings that we've been doing, all that kind of stuff that we've been doing, that WISPA's been doing, that Steve, et cetera, have been doing for WISPA, et cetera, as well as many other people. This is the actual court case that's finally coming up, that now the last step, all the documents have been uploaded, all the information has been given, and now we're at the point of the very last step. We give some oral arguments. In other words, everybody comes in front of the judges and states their opinions, and then hopefully we get a decision soon. Is really where we're at. We're finally getting on the end of this court case, and my assumption, this is basically, and again, I want to make sure this is correct. This is basically stating, can the FCC reclassify ISPs as Title II? Is that really what the issue is, or is there a broader issue in this case?
I think that's the primary issue. I mean, there's all sorts of nuances to that, but if you had to boil it down to a simple question, I think you nailed it, Dennis. Okay. What is the extent of the FCC's authority, and what is the extent of its discretion, and what sort of deference is it given? And that leads you back into a whole discussion of statutes and ambiguous statutes, and if there's ambiguity, that's an open door for the FCC to step in and exercise its discretion. But anyway, we'll crawl into that in a second.
Sure. Well, Steve has a question, and then we'll get to the court case here. Steve, what's your question there?
Being that you guys are like the Davids and the AT&Ts or the Goliaths, and you guys represent the small business entities that comprise WISPA, were you guys given an opportunity to speak at this thing, or were you just guys sitting in the peanut gallery?
Well, the way it works is this: is we all contributed to the briefs, and Dennis and myself and other people here, as we would get drafts from the law firm that was coordinating all of this, we would make suggestions, which were very well accepted. We made certain edits. We wanted to push forward certain arguments, and I think we were effective in doing that. When it comes to oral argument, the group as a whole selected one person to do our oral advocacy in both the first segment and the second segment. His name is Peter Keisler. He's a lawyer at a firm here in D.C. and has argued many appellate cases and Supreme Court cases. He's not the kind of guy who's just super smart. He's super scary smart and extremely articulate and adept on his feet. And I would say, in terms of how did he compare to the other oral advocates, I think he could have taken a knee. He was very polished, and I think he was probably the most prepared and best spoken. When you get up there in front of three judges for a half an hour and they try to take you off stride and interrupt you with questions, and you don't have any notes, and you're quoting footnotes and paragraphs, to me that's a fairly impressive person who's able to do that. So everybody doesn't get up and have a couple of minutes. It flows much better. You're sort of allocated a certain amount of time and one speaker, and that's what we did. And I don't have any regrets over the person that our group selected.
In addition to that, we also, in addition to having input on the briefs, there was a practice court, moot court it's called, where Keisler went through his arguments in advance of the argument itself, and we attended that, and we had input into that as well. So there's both input at the briefing and as a practice run for his argument. But it would be too unwieldy if you had too many people popping up, and it'd be hard to be cohesive and coherent.
Of course.
So that's the way it goes.
So I guess my last question on that is, all these oral arguments, are these public? I.e., is there a video or something like that our membership or our listeners could watch later?
There is an oral transcript that came out on Friday, and
okay.
I think that's available, and I can certainly send that link around for anybody who wants to listen to lawyers talk for 3 hours. I think listening to me and Dennis for the last 25 minutes has been painful enough, but I will be happy to do that. So
no video though.
And when I say the list, I can send it to the WISPA list, and you guys can further circulate it because it is public.
Gotcha. Not a problem. Well,
the Supreme Court doesn't allow cameras in the courtroom yet to film theirs, and neither does the circuit.
Yeah, well, it's not a big deal. I just curious because some people may want to have that. So with that said, then, what happened? What's the next step? Everybody, we now know the background. What happened while you were there? What was we represented well? Was we represented badly? Give us the lowdown.
Okay, so I mentioned there are 4 segments to the oral argument. The first part, 30 minutes aside, discussed reclassification from an information service to Title II telecommunications service, and also interconnection. The second segment covered application of these rules to mobility and something called the Internet Conduct Standard. Both of those first 2 segments also got into whether the FCC gave the requisite notice of what it was going to do. The third pod was 10 minutes on whether, on a First Amendment issue, whether the FCC's rules violate the First Amendment to freedom of speech. And finally, the last one was whether the FCC appropriately exercised forbearance, meaning that once they reclassified, what analysis did they have to go through before they said, well, we've got all these Title II rules and we're only going to enforce 27 of them, or whatever the number is. These guys were arguing that the FCC didn't have that authority and that the FCC should apply Title II without any sort of forbearance because the FCC had not done its job under the statute. So let me kind of walk through the first two and kind of give you a sense as to where things started. Our guy Peter started off framing the issue as one, as you mentioned before, Dennis. Does the FCC have the discretion that it claims to exercise utility-style regulation over the internet? And one of the things that we focused on, and this was a direct result of some of the things that Dennis to my left here said at the the practice argument on Monday, is the concept of retrieval and retrieving information, which has been regarded since 1996 when the Congress passed the Telecommunications Act, and even before that, as a core information service. And as an information service, it would not then be subject to Title II. Judge Tatel jumped in and said, what about this Brand X case? There was some ambiguity in that case way back when, and when a statute is ambiguous, we defer to the expert agency to make a decision. And the issue there was about the word offer and whether an offering of service somehow that word was ambiguous and gave the FCC the opportunity to reclassify. So we kind of took that point and said, there are some things, the FCC had said, we treat telecommunications service and we look at certain things as being, quote, telecommunications management. And the two things the FCC focused on, what the argument focused on, was caching. The ISP stores content, but doesn't change the content. And we said storage has always been an information service. It's kind of the flip side of retrieval, store and retrieve. And the other one had to do with DNS and whether that's telecommunications management or whether that's something else. One of the judges says, well, isn't DNS just like looking for phone numbers in the yellow pages? And we said, well, let's go back to the text of the statute, which talks about the capability to retrieve information, and DNS avoids you from having to know the IP address of every website you visit. There was some discussion about the events and statutes leading up to the 1996 Telecommunications Act. These are the FCC's Computer II regime and the modified final judgment that broke up AT&T, and a series of things that always regarded data access as being an enhanced service and later an information service when it was codified in 1996. There was some discussion about, back to the Brand X case, about the type of ambiguity. We had argued that the FCC was outside of the ambiguity in the Brand X case. I don't need to go into all the legal underpinnings of that, but it was kind of a significant point that the judges were asking about. Dennis, that's sort of my kind of in the weeds. Do you have any sort of thing you want to add to that?
Yeah, I think again to put a little different, put my own spin on it. Essentially, as we talked a little earlier, the case ultimately comes down to whether the court will defer to the FCC's judgment or strike it down for a reason they find sufficient. And the FCC holds a lot of good cards in typically in these battles. They will always try to drive the case toward ambiguity in the statutes that they are implementing, and which allows them to play their ultimate card of expertise, agency expertise. Courts are not expert in this. They hear cases all day, every day about a lot of different things. They don't want to be trying to become experts making line drawing decisions that is best left to the agency. So then the question becomes, from our side, challenging the FCC is to come up with a trump card to place on top of their cards. And one of the best ones is that the statute is not ambiguous, that in fact there's language in a statute that trumps what the agency tried to do. So that's where the storage retrieval issue that Steve talked about comes in. If in fact the court looks at the underlying statute and says, you know what, it's pretty simple that an ISP offers an end user the capability to retrieve information for their own purposes right back to the end user's desktop, then we have a potential winner there, because that is how an information service is defined by Congress. The ultimate trump card is, another way to think of it is, Congress can trump the FCC. So if Congress has spoken to an issue and they've laid out a blueprint, and the agency has strayed from that blueprint and gone off on a toot or off on its own pathway, and they've varied from what the statute requires, then the agency's in trouble in front of the court, because the court will say, no, you have not been faithful to what Congress has set out, and there's not enough ambiguity to get you into your expertise where you prevail. So that's essentially what reclassification is about. Is there enough argument on our side to get it out of ambiguity into a statutory argument or statutory land where we're on firm ground as opposed to thin ice? We're on thin ice if it's agency expertise. If it's statutory language that we can convince the court applies and decides the issue, we're on firm ground. So that's one way to think about it. Firm ground, thin ice on that argument. And so that leaves you back to what do the judges say?
Yeah, and let me kind of pick up here, because the FCC spoke next on this issue, and Judge Tatel, remember, wrote the Verizon decision, which was classified as a blueprint, and the blueprint said use Section 706 of the Telecommunications Act, which doesn't involve all this Title II stuff, but would give the FCC authority to adopt certain rules of the road. And the FCC's flaw in the Verizon decision was that it tried to characterize ISPs as common carriers without putting them in the right regulatory classification, so they didn't have a hook to hang on. So Tatel said, why don't you use Section 706, and why did the FCC abandon this? And the FCC said, well, based on the record, the service had changed. And Tatel really kind of said, but this was all, everything that you're telling me was all true 3 years ago when we made the Verizon decision. There couldn't have been any changed circumstances. And changed circumstances was in the FCC's order and as a predicate for them to adopt the rules. Well, the FCC said, well, we needed Title II for the bright line rules, which are no blocking, no throttling, and no paid prioritization. By the way, nobody is challenging those rules. So the question is, why do we need Title II for all this other stuff? Well, maybe you just need it, as the FCC initially stated, as a simple basis for authority for the FCC to adopt rules, but not an entirely new regulatory framework. And that's another issue, is, if the FCC had just says we're going to use Title II for the regulatory framework to adopt no blocking, no throttling, and no paid prioritization and stop there, would we even be in court? We'll never know the answer to that question. So finishing up on this issue, we came back at the end. We had a couple of minutes of rebuttal. And this is where I think Peter did a great job of sort of tying everything back to the regulatory regime that has always existed, that was codified in 1996, and pulled out some specific phrases to sort of put this back into, as Dennis was just saying, the statutory realm, and taking it out of the ambiguous realm. And basically saying, while this brand X case provides discretion, you need to look at the statutes and the history, and when you do so, you'll see that the FCC is not entitled to the deference that some would like to give it.
Yeah, let me just add to close out that first issue, which I think is the headline issue. And if the FCC were to prevail on Title II reclassification and lose on some of the other issues we'll discuss, they'd be dancing in the streets, because it would be a major shift in their power and would allow them to assert power over the internet in a way that's never really been sanctioned by a court before. To think of it in its simplest terms, I think the issue becomes whether what an ISP does is more akin to and better described as pure transmission with some management function added in the form of DNS and caching, or is it described as an information service within the meaning of the statute that Congress passed in '96? Is an ISP using computers to enhance information, to change it in certain ways, or to allow it to be stored, retrieved, doing more to the information than just purely transmitting it? And so I think at a very basic level, the court has to decide that question on reclassification. And if they conclude ultimately that that the statute and the terms of the statutes are ambiguous enough, then we get onto that thin ice of the commission's expertise. But on the other hand, if they just feel they're trying to jam this Title II common carriage onto the internet when Congress never really gave them any blueprint to do any such thing, they're really stretching it beyond where it can go, then our side prevails on that issue.
And I think both sides got tough questions, and I think anybody in the courtroom who says they know where the court is leaning is flat out lying, because we really couldn't tell. I think of all the issues that were discussed, this is probably the one where nobody really knows. And having read some of the stuff that has been printed by other people who were in the room, everybody kind of feels the same way, despite what your spin may be. So that's kind of where we are on that. Let me kind of talk about the next issue, which is interconnection. In the FCC's notice of proposed rulemaking back in May of 2013 or thereabouts, they said, we're not going to even involve interconnection in this proceeding at all. We may look at it separately, but we're not looking at that as being part of what we're going to look at here, the relationship between the ISP and the content delivery network or a Netflix. And then at the last minute, there was some last minute lobbying done with Commissioner Clyburn's office, who claimed in her statement that I've heard about all this, and I think, and she was successful in getting 3 votes to drop an interconnection obligation or an interconnection component into the rules. And what that says is that edge providers and consumers, or really anybody, can file complaints under Title II against ISPs based on discrimination or failure to negotiate. I guess that would be one thing. But if you, but the ISP doesn't have any rights to file complaints against consumers or edge providers. So it's truly a one-sided situation. Our argument, and the FCC did this based on the implied promise of common carriage. In other words, an ISP makes an implied promise to its customer that it will carry everything on the internet, that they're not going to block anything, and that they're going to connect with anybody who wants, or interconnect. There was some discussion about the difference between connection and interconnection in the court. So our advocate said that the order compels ISPs to act as common carriers because edge providers can file Title II complaints. But the FCC didn't reclassify interconnection, and this implied promise of common carriage is just pure fiction, and it was an excuse to apply Title II and is unlawful. So the FCC's response to that was somewhat convoluted. I didn't find it to be, just looking at my notes here, they said that they agreed they didn't classify interconnection, but said that the contract is, quote, in connection with, quote unquote, the provision of Title II service to customers and service to the edges within this implied promise. And they really just kind of reiterated what they had already said in their rules. And there was some question as to whether, so I think on this one, the FCC got some very tough questions, especially from Judge Williams. A lot of it had to do with about the predictive regulatory model the FCC adopted, with Judge Williams saying, well, there hasn't been any paid prioritization issues. He also noted that some economists have put a brief in that talked about, aren't there less restrictive ways to accomplish these objectives? And the FCC's response was, well, we need a case-by-case approach for small edge providers, at which point I nearly jumped out of my chair and said, well, what about small ISPs? They didn't get into that issue, and they didn't go there. But there was a lot of discussion here about whether the FCC was on thin ice or solid ground with their interconnection approach. And just sort of hearing things, and without getting too far down the road, I tend to think that we have the better argument on this one.
Yeah, I think the interesting part about this is the focus shifted from the end user sitting at a desktop out to the edge where the Googles of the world reside. And Steve explained it just right. The lobbying prevailed. They got the right to file complaints. But a major part of Keisler's argument was not just that it's fiction, but why it's fiction. That in fact, the agreements out on the edge, particularly, of course, with the larger providers, the larger ISPs, are subject to individualized negotiation. It's not common carriage at all in that respect. It is a private contract with differing terms depending on the edge provider and the ISP, and that is not at all the sort of undifferentiated one carry all concept that is typical of common carriage. So one of the interesting things is, if in fact we're on solid ground there, then how does that affect the overall decision? If the court is dissatisfied with the interconnection, the extension of regulation out to the edge and allowing complaints to be filed at that frontier of the internet, what does it do to the entire decision at the commission? Would they strike down just the interconnection component and leave the rest of the Title II in place, or not? Does it have broader implications for what the FCC did? So that one is left to the judges. That's where the judges' expertise comes in, as to how they're going to provide a remedy if they're troubled and are not persuaded that interconnection regulation will survive.
We talked a little bit about notice before, and the FCC is required, like all agencies, to provide notice and afford an opportunity for comment anytime it wants to adopt a rule. And there are at least 3 instances where the FCC, or 2 instances where the FCC, where we argued that the FCC had not provided sufficient notice. And one was, as I mentioned, with respect to this interconnection issue, when the FCC, when it basically came up in the last few days before the FCC adopted its order, and there was no opportunity for comment because nobody had ever heard of it. And so we made a pretty strong push at the end there that the order should be vacated for lack of notice. There was also an argument about the lack of notice on Title II, because all the FCC did was ask a bunch of questions and suggest that maybe they were looking at Title II as a source of authority. Our argument is, yes, that's one thing, but we did not sort of fully appreciate that this was going to lead to a whole new regulatory regime, and there was not fair opportunity and notice to respond. The third one arises, and this came up in the second argument, has to do with whether the FCC should apply these rules to mobile broadband services. And here there's a different statutory construct, whether this deals with a packet switch network on one hand, or the public switch network on the other hand, which is one network. Judge Tatel, I think, kind of went ahead here and says, well, I've got my cell phone here, but I can't reach everybody who is using IP-based telephony services. But if I have my smartphone, I'm better able to do that. So how can you say that this is sort of common carriage when not everybody has the same device? In other words, it's not like a telephone. And our argument there was that the notice violation here was particularly stark because nobody had any inkling that the FCC would change the rule. There was only one sentence in the notice, and it was in a footnote, and it never suggested the FCC would go this route. The FCC said, well, should we have to lead you around by the nose? We shouldn't have to walk people around by the nose through the process. And I think we very effectively said, well, it's one thing to put a statute in a footnote. We know where to find that, but we don't know what the agency was thinking. And I think that was a very sort of effective little punched up argument there on where the FCC may have some issues when it comes to notice violation of applying its rules to mobile services. And this was in the second part of the argument, for which there was 20 minutes aside afforded.
This argument also comes down to the words in the statute. A primary issue on the mobile side is whether the historic regulation and the blueprint Congress provided, which uses the term public switch network back in '96, whether the public switch network is, number one, a single network, right, that is the telephone public switch network, even though the word telephone does not appear in the statute. One of the things I always find fascinating is, well, as you go from one piece of the argument to another, the same kinds of battles are fought. What does the statute mean? What does it actually say? So if you go back to our first part, the word retrieve is actually in that statute, so you have to deal with it. Here, the word telephone is not. But did the absence of telephone, when you're talking about public switch network, allow the FCC to charge in and say, well, telephone's not there, so we're going to define public switch network to include not just telephony, but the internet itself. So we're going to broaden it and make it like a two-headed definition: internet plus telephone, and the public switch network. So it's a mobile argument, but it's again goes back to the same kinds of arguments within the oral argument. Do you have a trump card? What is the language used in the statute? Telephone's not there. Does that decide it, and that has allowed this agency to come in and say, well, we're the experts, and we're going to, and that's where Judge Tatel was going. He says, well, look, if there's just one network, and now it's got internet using ISP addresses and web addresses, and the telephone company using the North American numbering system, if my phone only can make phone calls and it cannot connect to web addresses, how am I interconnected to the entire newly defined network? Right, that has both an internet component and a telephony component, and that's one of the things he was troubled by. It seems like the network, you've stretched this definition of public switch network so broadly to include the internet that it doesn't work anymore. It's too broad because it's not a single network, it's not unitary, and all users are not connected to it at all times. So things like that are very interesting. In the course of an argument, the government, I don't think, had any real great answers to that problem. Judge Srinivasan, who we haven't talked about a lot, he said, the problem I have with this is that now I'll be in my home. If I'm sitting at my laptop, I am on an ISP, but if I'm on my phone, for example, and we find that the mobile device can't be regulated as common carriage, I'm going to be sitting at my desk on a common carrier. Then when I move to a different part of my house and I go to a mobile network, I'm not. The whole thing then becomes somewhat unwieldy, and it doesn't make a lot of sense from a 30,000-foot level, because you've got two different, one a carrier and one non-carrier. So I think they were grappling with, and I think that's a function of the FCC trying to, again, jam common carrier regulation into the internet, into a hole that it's more doesn't fit so well.
So one other argument here, which is actually one that I'm especially fond of, in the notice of proposed rulemaking, the commission had initially proposed to ban certain practices that might be commercially unreasonable. And they abandoned that in the final order and adopted something called the Internet Conduct Standard, which says that ISPs shall not unreasonably interfere or unreasonably disadvantage end users and edge providers. And they provided 7 non-exhaustive things that might be used to inform whether you have violated this standard based on the totality of the circumstances. This is a lot of legal mumbo-jumbo, and our argument there was that this was a vague and impossible standard on top of 3 bright lines. Remember, this applies everywhere. So even if you are not blocking, not throttling, and not paid prioritizing, you can still be subject to violations of this very vague and broad and impossible standard called the Internet Conduct Standard. And our argument is that the way to address this is through a notice of inquiry and a notice of proposed rulemaking, not via retroactive enforcement. Even the FCC has admitted there is uncertainty with respect to this TMO music freedom, and I guess it's binge-on service as well. And this subjects every business practice to after-the-fact decision-making, and it's a classic definition of arbitrary. Interestingly, no judge asked any question, and the FCC didn't address this at all in its argument either. So very difficult to gauge where this argument is going. My feeling is that if we win on reclassification, but the court concludes that the FCC had authority under Section 706 to adopt this standard, it could become even worse than Title II, because they'll just try to incorporate Title II as they go along and build it back into this Internet Conduct Standard. So that's kind of a scary thing, and I kind of hope there would be more discussion on this, but we said our piece. It's fully vetted in our briefs, and we can only be hopeful that the FCC will that the court will do the right thing on that one. So the last 2 arguments I won't spend a lot of time on, because I know you may have some questions. I mentioned that there was a First Amendment argument that was raised by a couple of the petitioners. They had 10 minutes aside, 10 minutes for them and 10 minutes for the FCC. This was not an argument that WISPA raised, but was raised by other petitioners. And the first question from the judges was, well, is this a backup argument? Are you saying that the First Amendment applies only if you lose on reclassification, then we should throw it out based on First Amendment grounds? And the answer to that question was yes. And the first thing that occurred to me was, well, if the FCC declares that you're a common carrier, then that seems to me to want to diminish your First Amendment rights, just basically because all you are is truly a dumb pipe that doesn't change the content. So I thought that was a little bit of a stretch for the petitioners to make that claim. And the second thing they said was, well, ISPs are just like gatekeepers, and they act like cable companies, and they can provide whatever programming to you that you want. And there's this, friends and family or family-based service, internet packages that are permissible. I don't think the judges were buying that at all. So, Dennis, maybe you want to respond.
Yeah, not worth a lot of time. I mean, they're caught between two positions. If in fact the government used the term curating, but really it's if you're curating your service. In other words, you're not providing access to all the edge providers out there, but you're picking and choosing among them and offering your subscriber a limited selection of edge providers. Well, once you do that, you're really not a carrier, but you're in a different category altogether, and you do have First Amendment rights because you are picking and choosing. But if you are an ISP that is actually providing unlimited, uncurated, unselected access to the edge provider universe, and the court agrees that becomes the dumb pipe, as Steve said, then you're out of the realm of that First Amendment for the most part. You are just offering transmission service, and you're not a speaker. You're not actually making selections. You're not speaking in that sense. So that's it. And so so if you're a selective service, you're not a carrier to begin with. Pretty easy. And if you're unselective and a broad carrier, then you're just a transmitter and a transmission service, and you're not going to be treated like a speaker with First Amendment rights that go with it.
So the last argument, 10 minutes aside, this was the group that suggested that the FCC should apply Title II full throat, full bore, without any forbearance, without saying that some of these rules shouldn't apply. And he got about 4 or 5 minutes into whatever it was he was saying, which I couldn't really follow. And one of the judges says, "Isn't this about forbearance?" And he was like, "Oh yeah." And then he went into sort of saying that the FCC's light touch policy hasn't met the predictions, and the FCC said forbearance was part of the overall regulatory structure, so we could tailor the rules to the internet, kind of a square peg round hole argument, and the FCC made a judgment call about what to keep and what to forbear from. I think on this one, again, I don't think that the petitioner's arguments made a lot of sense. Say what you want to about Title II, but I would think that the FCC would have the discretion to exercise forbearance based on the statutory discretion it's given to do so based on a public interest test. So my sense there was that this argument isn't going very far. That was my sense before I went to court and heard the argument. And I don't think they were very effective in persuading the judges.
This group has a whole different slant on everything, basically, from our group's slant. And it starts with the 96 Act. Our view of that is it's 20 years ago. Internet was not front and center for Congress. They didn't create a blueprint for regulating the internet, and the commission is trying to jam the square peg into the round hole. Their view is the internet was in existence in '96. Congress did take a comprehensive look, and intended that act to cover everything, including forbearance. And the commission doesn't have the discretion to forbear from so many parts of Title II. They need to apply even more regulation. So, but they're both petitioners, and that's the way these cases go. Anybody who doesn't like what the FCC did is a petitioner, even though their viewpoints were very different from our viewpoints.
So one last comment here, and that is probably taking it right back up to 100,000 feet, is the reason that the FCC is here and that we're here is because there was I think we can say whether you believe there's ambiguity or not, but clearly Congress has abdicated its responsibility to provide the FCC with clear policy and law on what it should do. The FCC was handed a court case. It was remanded to them. Congress did nothing or could do nothing to kind of provide the guidance. The FCC said, well, it's been remanded to us. We've got to do something. We certainly disagree, and a lot of people disagree on what the FCC did. But this is sort of a metaphor for the administrative state that we live in today, which is if Congress isn't going to do it and somebody rightly or wrongly perceives a need to regulate it or to unregulate it, then that's up to the agencies. And that's the position the FCC found itself in, is lacking clear guidance from Congress on what to do. So they made it up as they went along, and here's where we are. So I think that's all that I have. Dennis, I don't know if you have anything to wrap up with, but we're happy to take some questions that you guys have, because I know we've been sort of pontificating here for quite a while.
I'm good.
Well,
I have a question.
yeah, Stephen has a question to get started.
So, from what you guys mentioned, to me it sounds like the FCC was unprepared, and to me it sounds like a summary judgment against us should take forth for their lack of notice. I mean, these are trained professionals, you would think, that know that they have to give fair notice about a lot of these issues that you talked about, and they didn't. I mean, how can these judges look at the FCC and consider them experts? I mean, this to me sounds like the Affordable Care Act. Pass it and then we'll figure out what it's all about.
Well, deciding what constitutes good notice has been litigated for years and years and years, and the rule of law is that the rule must be a logical outgrowth of something that was in a notice, and how one interprets what is a logical outgrowth or not is
ambiguous.
Well, it's certainly up for discussion, and there's certainly reasonable people who can disagree on what constitutes notice. The FCC will say, how can you say there was no notice? Look at the record. We had 4 million people write in, and we got some very detailed comments from you, CTIA and AT&T, on on Section 332, which is the section that was debated here. How can you say there was no lack of notice? So that's a little bit different than the FCC saying, well, we're not going to talk about interconnection here, and then at the last minute dropping something in. Now, those are different. They may lead to the same legal outcome, but factually, the notice is a little bit different. And then, as we talked about with Title II, the FCC mentioned it specifically and asked a bunch of questions about it. Well, asking questions, is that notice, or should the agency actually have to propose rules? Well, the answer is, in a perfect universe, they would propose rules. But here they didn't do that, but they're not required to be perfect. So they're just required to base their decisions on the record and have them be a logical outgrowth. So very good question, and a lot of time was spent in the briefs discussing that. And I think we have sort of three different flavors of the notice question that's been presented here.
And one last question. To me, the last comment you mentioned is, it sounds like Congress kicked this can down the road and didn't want to deal with it, so they turned it over to the expert regulatory agency to fix. Is that what is that kind of what you said?
Not exactly. I think it's more that assumes that they made an affirmative decision on Capitol Hill to turn it over. I think it's more fortunate byproduct of dysfunction up on Capitol Hill and the inability of that bunch to pass any legislation, especially important legislation on something as important as the internet. So it's more a void or vacuum than it is a directive or you guys do it. There's nothing really to suggest that so much as there is nature abhors a vacuum, and so does the FCC. So and Steve, as Steve said, they had a court remand and they needed to respond to that, so they went for it. And they got a new chairman, Tom Wheeler. President Obama weighed in very prominently in the fall, saying he wanted, a full and open internet. He wanted ISPs regulated, and so that changed the whole dynamic in this matter. Instead of going with Judge Tatel's limited blueprint that Steve talked about, they went whole hog in for Title II, a la President Obama. So that's what happens when Congress sits on its hands and is dysfunctional, I think, and that allows the agencies to go in and claim ambiguity and fill the void. And now the court has to decide, Congress hasn't done much, but have they done enough to give the agency enough to do this?
Yeah.
Interesting question.
So,
I'd say on notice, let me add quickly on notice, it can go all kinds of ways. If, for example, it gives the court some refuge. If they don't like what the agency did here, but they're not, prepared to necessarily reverse them on the merits there, they could go to notice and say, as a stopgap for them, and to say, we don't like the notice here. Logical outgrowth gives the agency a lot of leeway to say very little and then do a lot. They really get into trouble when they say absolutely nothing. But when they say a little bit of something in their notice, they can use that and parlay that into a lot of different actions. But a court can also come back at them and say, we don't find your notice adequate. So it's that would be an unsatisfactory result to both sides if it came down to notice, because we're right back at the agency again for them to try to do the same thing with better notice. However, courts sometimes pull that trigger.
So with that said, I think we have a couple questions. We'll try to wrap things up once we get some of these questions. I know we do have a couple questions from our listeners, so that's always a really good thing. I definitely think, going back to what Steve just asked, the Congress didn't do anything, and they could have said, no, we're not going to do anything. They could have passed legislation to that effect, but that's not what they did. They just literally didn't do anything, and that's what really left it open. So let's go back to some of these other discussions. And again, this is just some questions from our listeners. This one is directed to Steve and Dennis, of course. Specifically, I'm just going to read this verbatim so that we don't get it lost in translation here. Why did the questioning seem to focus on past court cases, such as Brand X, which are not directly relevant, instead of returning to the fundamentals of law, which plainly states that reclassification is illegal?
Well, I think, to be fair to the court on Brand X, the fundamental holding there was right within the sweet spot of what we've been talking about today. The ambiguity and then agency expertise, and the court stepping back and saying, once we're into ambiguity, once the agency is filling holes in the statutory landscape, then as a court, we can't second guess and redo that work. Even if we would decide it differently, if we were empowered to do so from the get-go, if we had the decisional stick in our hands, we would decide something different. But that's not our job. Our job is to review whether the agency gave enough of a rationale for what they are claiming to do. So the court's role is limited in review, and that's why the agency wins so much of the time, because they have a lot of discretion, a lot of leeway in this kind of case. And Brand X really stands for that proposition, because remember, Brand X, the FCC went the other way. There, when they were deciding whether cable modems and cable internet service should be regulated as a common carrier or regulated at all in the same way, the agency said, no, we're not going to do that. We're going to treat them as an information service. We're going to approach it as hands-off. And we're going to even treat the transmission component of the cable service, the pure transmission, as an integral part of the overall cable service they're providing. So the point is, they went in the exact opposite direction in Brand X, and all the court did was say, well, there's ambiguity in that term offer, and so we're going to defer to the agency's expertise in that case. And that's why the agency can try to use Brand X for the exact opposite 180-degree decision here to go common carrier Title II, saying, again, we're looking at the totality of the facts in 2015, and we're deciding to go with telecommunication service. So that's I think it's just the way the system is set up, with the agency making the first decision. They get to go first. They'll drive it to their expertise, and the court just sits in judgment on whether they gave enough of a reason for what they did.
So let me answer the question a different way, because I think the first part of the question is, why did the judges ask the questions about ... And it raises an interesting question about why judges ask questions that they do. I think in some cases it's to really find out, because they're unsure after reading the briefs as to what you're trying to say or what your position is. I think in some cases it's to be devil's advocate. I think in some cases it's to test your own theories against people who may agree or disagree, so that you can clarify the issue in your own mind. And I think in some cases it may signal the other side as to where you're thinking, so that you might want to say, hey, I'm thinking about this, you FCC, you're sitting there, you're up next. You might want to be prepared to answer these questions too. So, there's a lot of reasons that judges ask questions. I think, as we've been saying, I thought we found them to be very well informed and the questions to be good. And some of the questions you can read into whatever you want about the line of questioning, but I think they really did do a good job of bringing up the salient and important arguments.
Excellent. So another question we got is, I think it's more of a question: what would actually happen? One of the comments is they're expecting, or one of the listeners is expecting the court to remand the order on procedural grounds. Now, does that fit into where you said, from A to Z, the court could say it remands everything, or it remands nothing, or it can do anything in between? If they remand on this order of procedural grounds, the commenter, our listener, basically said this would probably be bad for us because we're not really settling anything. They're saying they didn't follow procedures, so they have to go back and follow procedures and keep doing it again and then come back. So in other words, we just go in a big circle. Is that correct, or are we off?
It's an interesting question. I think the procedural issue would be that the FCC failed to provide notice of anything that it was going to do. That's sort of the most obvious, kind of way to think of this, at least in my own mind. And if that was the case and it went back to the FCC, let's keep a couple of things in mind, and that is that we have an election coming up this year, and that will the FCC won't be able to, if there's a decision handed down in spring, to kind of put a new notice out, adopt rules, and so forth in sufficient time past the election. So whether it's a Democrat or a Republican who is elected, it for sure won't be this particular guy. I don't think Commissioner Wheeler is probably going to stay there past this term, although people may differ on that. But we're going to have a new FCC. We're certainly going to have a new White House, and we're certainly going to have a new administration, and we may have a different composition of Congress, and we're certainly going to have some new FCC commissioners. So you kind of are starting all over again, and the engineers and the economists and, dare I say, the lawyers will be back at this again, I'm sure. So that's sort of one way to look. Does that make it better or worse? I guess if there are no rules and we're back to the 2010 rules, we're still living under a light touch regulatory regime. So I think that would be a great outcome, but we'd certainly be dealing with the uncertainty of what's coming next.
Gotcha. So in other words, next thing you know, they could come back and try to do the same thing again if they wish to, because it wasn't said that they can't do it. They just said you did something incorrect in the procedures, and because of that, you have to go back and try it again, which is, I can understand that. It's a long and drawn-out process and kind of a pain in the butt. For our listeners that are online, our live chat does have the audio link for the court website that will allow you to listen to all those. It is looks like it's U.S. Is it? And I want to make sure USTA versus FCC. Would that be correct?
Yep. Yes.
Okay. So if anybody wishes to go and listen to a whole bunch of fun stuff, you are more than welcome to, and we do have that link available as well. With that said, I'm just going to look here for any other questions.
Let me add one anecdote
Sure.
on that last question about what courts do and what impact it has. Just a couple of years ago, the Supreme Court had in front of it a question about whether the FCC could regulate broadcast indecency the way they had been doing it for a number of years. And these cases, because I have a lot of familiarity with it, they take a long time to tee up and get in front of a court like the Supreme Court. And the industry was hoping for a First Amendment decision on the merits, a victory of sorts that would have real consequence, by saying that the way the FCC was regulating indecency was unconstitutional and violated the First Amendment. But in the end, the court went off on procedural grounds, just like we're talking about in this case. And the Supreme Court ruled in a unanimous decision that the FCC had provided an adequate notice of what they were doing in that sphere of regulation. In other words, they had not, the industry could not tell which end was up when trying to decide what they could or could not air when you're dealing with sexual issues and things like that. So they found inadequate notice, and they just remanded it to the agency where it sits to this day. It was a 2012 Supreme Court decision, and it effectively paralyzed the agency because a new chairman was in place, had a different approach to the issue, and it's now just sat there with no indecency regulation for some time, except in a rare instance. So it happens, and we did talk about that as one possibility here. If notice is the grounds, it'll go back, but where it comes out, under new chairman a couple of years from now is very uncertain.
Gotcha. Excellent. I think we have answered all the questions that has been presented to us on our chat. I would like to thank both Steve and Dennis for coming in on here and really giving this is a really great line of questioning and comments on what actually occurred.
Real timely.
Yes, and of course timely. I know you as lawyers probably don't like to speculate on the outcome. Do you have a feeling? Anything like that?
Okay, I'll go first. I'll take the I think the FCC is on very shaky ground when on interconnection and on the extension of the rules to mobile services. I think the First Amendment argument is not going anywhere. I think the argument from the CLEX that the FCC should not have exercised any forbearance is, well, my own perception of that has always been that it's almost laughable. So where does that leave us on things like notice and internet conduct standard and reclassification? I think I'm going to wimp out on that and say I don't know where the court's going to go because
fair enough.
While I feel very strongly about our positions, I also know that it's certainly not a slam dunk, and I'm not going to say anything. I don't have strong feelings one way or the other, and maybe Dennis has a different take, but that I didn't come away from reading the briefs and hearing the oral argument thinking that there was any one particular way this was going to go. And you're dealing with three judges who may see things very differently and may not have revealed their intentions through their questions. Okay, your turn.
Well, I can't disagree. I think the big issue is reclassification. Yeah. As I said, if the FCC gets affirmed on that, it's a huge victory for them. It opens up a whole new world for the FCC to make mischief with the internet and how they regulate it. And I think my own sense is that our side had the better of it in the briefs. We had a better oral advocate in front of the court. I think we should win. I think this is a bridge too far that the FCC is trying to build to get to Title II regulation. Mm-hmm. They're trying to use a 96 Act to impose 1934 style regulation where Congress has been on the sidelines. I think it's a bridge too far. However, the one concerning thing I had was that I didn't feel that the judges asked enough penetrating questions of the FCC to give me comfort. They weren't particularly hard on them. Tato was unhappy with their failure to explain the changed circumstances and why this was different in 2015 than 2012-13 range. However, there were other questions that went unasked that I would have liked to have heard from the judges to feel more comfortable with where this is headed. So it's a toss-up, and it's hard. It's really impossible on the reclassification, I think, to come up with a really good risk assessment or a chance of success assessment.
I think we're kind of on thin ground or solid ice on that one to pick up our theme. So,
yeah. Well, like I said, I mean, you never know, and from what it sounds like to me, and this is again just my opinion, is that there are various aspects that are a plus, and there's various aspects that are minus. So whenever you said, either it's going to vacate the entire order or it's going to uphold the entire order, I think it's definitely going to be in between there somewhere. But that's why we have these arguments and why we have all this stuff, so that we can take this information, or at least these three judges can, and then they can discuss amongst themselves to come up with a much better solution, or at least compromise inside there based on what the past and the laws are. So I don't think it's going to be a slam dunk. I don't think it's going to be a vacate everything, but I definitely think that there will be some pluses and minuses. And what was your time frame for us to hear something?
I think I've heard March, I've heard May, so I think sometime in that time frame.
March, May. Excellent. Not a problem. Well, with that said, I think I got all the questions that we have on our live chat, and I have all the questions that I have. Steve, do you have anything else?
Before the show, Stephen said he wanted to update on a few items. So
take it away,
Steve.
Yeah, so I went to I visited the FCC today on behalf of WISPA and met with the chairman's wireless advisor. As folks know, WISPA has been, along with other associations, has been asking the FCC to not impose these new open internet disclosure requirements on small businesses. And the FCC originally granted a temporary exemption until December 15th, which is next week. So I checked in with the FCC, and they are going to put an order out probably sometime next week. They're going to circulate it to the other 4 commissioners probably tomorrow. I don't have a strong sense other than what they've said is they're going to strike some sort of a balance between those like us that want an indefinite permanent exemption and everybody else are in those, and I don't know who they are because I can't remember, who asked for something to be more short term. My guess is they may do some sort of a sunset and we'll revisit it in a couple of years, but I don't really know. The other picture is that those new disclosure rules are not even in effect for the big guys because they have not been approved by the Office of Management and Budget under something called the Paperwork Reduction Act, because the FCC totally underestimated the burdens that these new rules would have on small businesses as well as big ones. And that's not supposed to be done, I'm told, until April. So regardless, there are no rules that are effective now for anyone, small or large. Probably won't be until April, and beyond that, we'll have to see what's in the FCC's order. But we will see something next week on that. And secondly, with respect to the template, the label for your safe harbor disclosure of your internet practices, the Consumer Advisory Council, on which WISPA President Alex Phillips spoke, was on, presented a proposal, kind of a label, like I think nutritional label type proposal to the FCC at the end of October. And we should see FCC approval or modification of that probably the week after next. So still a few things to go before we unwrap the presents, but I guess those will be the FCC's gifts to us.
Fine.
So in reality, what does that mean to me, an ISP? Do I got to come up with a document on my website saying, I don't throttle traffic, I don't do this, I don't hurt your feelings, I'm trying to be a fair player here? Is that kind of where this is coming down the pike in about April, you said?
Taking your question as a hypothetical, all ISPs are required to comply with the 2010 rules, which require you to make certain disclosures about pricing and performance and network capabilities. What the FCC adopted most recently would enhance those disclosures and require more detailed disclosures. So every ISP is now required to post at its office, its point of sale, as well as on its website, what its open internet policies are based on rules that were adopted in 2010.
Thank you.
Excellent. Well, Steve, you want to wrap us up?
Well, yes, I want to thank Steve Coran and Dennis Corbett with Lerman Center for being on the show and telling us in a timely fashion, what went on just last Friday in regards to this whole thing. And it looks like that we're, to me, I'm kind of amazed that we got in front of a court this quick, number one. And number two, I'm impressed with our industry sticking up for ourselves by having Steve and Dennis work this for us. I mean, we would be without a voice, if you will, had our organization not solidified and got us the representation we have. And I appreciate you guys doing what you guys are doing for us. It's a monumental task, I'm sure.
Thank you. You're quite welcome.
Well, with that, we will wrap the show up. I want to thank them again, and thank you for listening in. Have a great week, and go out there and do some good, guys.
Thank you for listening to ISP Radio. We hope you've gained new insights and additional wisdom in our industry as well as your business. Please remember to visit our show sponsors via the links on ispradio.com. If you're interested in becoming a show sponsor, contact us at sales@ispradio.com. Now go out there and push those packets as fast as you can. Good luck and Godspeed.